मी बार काउन्सिल ऑफ महाराष्ट्र आणि गोवाच्या वतीने आपल्या सर्वांचं स्वागत करत आहे. आज आपल्या या 11व्या लेक्चर सिरीज मध्ये मी आपल्या बार काउन्सिलचे चेअरमन, व्हाईस चेअरमन, कोऑर्डिनेटर ऑफ प्रेझेंट लेक्चर आणि इतर इस्टीम मेंबर्सचं पण स्वागत करत आहे. आता आपल्याला आजच्या प्रोग्रामसाठी जे लेक्चर सिरीज साठी लाभलेले आजचे रिसोर्स पर्सन आहेत ते आहेत ऍडव्होकेट डॉक्टर Rajendra Anbhule sir. It is my honor to welcome and introduce our today's resource person, Advocate Dr. Rajendra Anbhule sir. On behalf of Bar Council of Maharashtra and Goa, I welcome you, sir. Sir has varied achievements. Sir is LLM PhD from ILS Law College. Sir has secured gold medal in LLM Pune University. Sir completed the PhD in law in the year 2013. Dr. Anbhule sir has authored several books on law. To name one is a book for students aspiring to judicial services. He has associated as a resource person for Bar Council of Maharashtra and Goa, Yashoda Pune State Women Commission, Women and Child Department, Maharashtra Police Training Center, Police Research Center, State Intelligence Bureau, amongst other reputed institutions. Sir, Dr. Rajendra Anbhule sir is Supreme Court advocate on record, practicing in Honorable Supreme Court and present Bombay High Court. His esteemed achievements and sir is on the panel of Savitri Phule Pune University, Spicer Adventist University, Pune, Indian Institute of Science, Education and Research, Pune, and other reputed institutions. Sir is dealing with several kinds of matter, including constitutional laws, civil laws, criminal laws, land laws, labor laws, trust laws, personal laws, commercial laws, service and educational laws, arbitration laws, and there are several reported judgments to his credit. Now, on behalf of Bar Council of Maharashtra and Goa, I hereby request Advocate Dr. Rajendra Anbhule sir to take over and guide us on the topic of domestic violence. Welcome you, sir, and over to you, sir.
Thank you, Anushka, madam. Am I audible?
Yes,
sir, you are audible.
Yes, sir.
You are audible.
At the very outset, I am very much thankful to Chairman, Vice Chairman, and all the members of Bar Council of Maharashtra and Goa for giving me an opportunity to discuss the topic of the protection of women from Domestic Violence Act from the point of view of preliminary examination of family court judge. Before starting this particular topic, let me clear one thing. As you all are going to appear for preliminary examination, wherein multiple choice questions are going to be asked, today's discussion will be confined to multiple choice questions in relation to the Statute of 2005. While discussing this particular topic, I will also refer some judgments of Honorable Supreme Court of India, wherein court has tried to clear the law in relation to some important concepts of domestic violence, be it a concept of continuing violence or even a concept which are developed by Supreme Court of India in relation to maintenance. As we know that the Domestic Violence Act is Act number 43 of 2005. This law has been enacted in 2005. Despite that, on 26th of October 2006, this law came into force. That's why the first and foremost aspect is that when this particular law came into force, the answer is this law came into force on 26th of October 2006 when some rules were framed some rules were, we may say, pronounced by Government of India under Section 37 of the Act. Now, before starting this particular topic, it is essential to discuss some basic important aspects in relation to the preamble of this particular act. If we see the preamble of this particular act, two important aspects are provided: that why this law is required in India, or why this law is enacted in India. The first important aspect is there in the preamble, that is, this law has been enacted in India with a view to provide effective protection to the rights of women guaranteed under the Constitution of India. More particularly, those women who are victim of violence of any kind within the family. So two things are there. With a view to protect the rights of women under the Constitution of India, in relation to those victims who are victims of domestic violence, this law has been enacted in India. Now, if we see the statement, object, and reason of this particular act, then we'll come to know that this law is enacted in India because of the international pressure and international force. As we know that in 1989, Convention on Elimination of All Kind of Discrimination Against Women was ratified by United Nations. There was one recommendation of this CEDAW, that was a general recommendation number 12. In this general recommendation number 12, it was suggested by the United Nations that all the state parties should come together and they should enact a law in relation to those women who are the victim of domestic violence. And let me tell you one thing very important in relation to the CEDAW, that is the Convention on Elimination of All Kind of Discrimination Against Women, that it provided that if violence is committed in any family, then it is a human right issue. So CEDAW for first time recognized that domestic violence is a human right issue. And after CEDAW, that is the 12th recommendation, question may be asked in the exam that by which recommendation of CEDAW it was provided that the state parties should act and they should enact a law in the respective states. The answer is General Recommendation number 12 of 1989. Now, whatever CEDAW discussed, that was acknowledged further by Vienna Accord of 1994. And again, Beijing Declaration and Platform for Action of 1995. Now, Vienna Accord of 1994 and Beijing Declaration and Platform for Action of 1995 were the two documents wherein also it was recognized that domestic violence is a human right issue and all the state parties should come together and they should enact a suitable law ameliorating the position of women in their respective societies. And for that purpose, it was suggested that in respective states, the act like Domestic Violence Act should be enacted. Now, so far as India is concerned, we all know that in 1983, Indian Penal Code was amended and Section 498A was inserted. Now, Section 498A deals with cruelty as an offense, which is a cognizable and non-bailable one. But as far as civil area is concerned, till 2005, there was no civil law which address or even redress the phenomena of domestic violence in its entirety. That's why, as criminal law was there in respect to Section 498A, there was no civil law, effective civil law in India, which will consider the problems of women who are victim of domestic violence and which will provide a suitable remedy for the enforcement of their basic human rights. So civil law was not there which could address the phenomena in its entirety in relation to the domestic violence. And as answer to that, it was suggested that there shall be one law which will effectively provide protection to the women who are victims of domestic violence. And for that purpose, in 2005, this law has been enacted. Third important aspect is there after 498A and international pressure or international, we may say, recommendations. And that is Article 14, Article 15, and Article 21 of the Constitution of India. Now, as far as Constitution is concerned, there are three important articles. That is Article 14, Article 15, Clause 3, and Article 21. Article 14 says that state shall not deny to any person equality before law and equal protection of law within the territory of India. Article 15, Clause 3 says that nothing shall prevent the state from making any special provision for women and children. And Article 21 deals with right to life and personal liberty, that no person shall be deprived of his life and personal liberty except according to the procedure established by law. So, keeping in view the rights under Article 14, Article 15, and Article 21, this law has been enacted in 2005. So, question may be asked in your exam that the Act of 2005, that is the Protection of Women from Domestic Violence Act, has been enacted, keeping in view the following provisions of the Constitution of India. In that case, the answer is Article 14, Article 15, and Article 21. Now, as far as statement, object, and reasons are concerned, one important aspect has been mentioned there, and that is, as I said earlier, that the civil law in India did not redress the phenomena of domestic violence till 2005. And for the first time, to redress that particular aspect, in 2005, the law has been enacted. Now, another important purpose, as I said earlier, is that this law provides effective remedy in civil law to the victim of domestic violence. So in statement, object, and reason, it says that with a view to provide civil remedy, or with a view to provide remedy in civil law, this law is enacted. And if you see Section 28 of the Act, then it has been mentioned there that while disposing of an application filed under Section 12, the procedure prescribed in CRPC is to be followed. So there may be doubt in your mind that whether this particular law is civil or whether this is a criminal law, or whether this is quasi-civil or quasi-criminal. This debate was there even in Bombay High Court also. And in 2018, Bombay High Court has decided one case, that is Nanda Kishore versus Mangla. This is a full bench judgment of Bombay High Court. The citation is 2018 SCC Online, Bombay High Court, page 923. In Nanda Kishore Vyavare versus Mangla case, Bombay High Court has clarified that Domestic Violence Act is basically or predominantly civil in nature. Any application which is filed under Section 12, summons issued under Section 13, concealing under Section 14, and specific orders which can be passed under Section 18, 19, 20, 21, 22 in respect to protection orders, residence order, even monetary relief, even custody order or compensation orders are in form of civil nature. That's why Bombay High Court clarified in full bench judgment of Nandakishore Vyavare that this law is basically or predominantly civil in nature. If any order is passed by magistrate under Section 12 of the Act, that is we may say protection order or interim protection order under Section 18, and if there is a violation of that order, then for breach of that protection order, Section 31 of the Act has provided a penalty. So, respondent is liable for 1 year punishment and also 20,000 rupees fine. And if you go to Section 32 of the Act, it says that breach of protection order is cognizable and non-bailable. So, even though this law is civil in nature, under certain circumstances, if the protection order is not complied, or if there is a breach of protection order, then the respondent can be punished for 1 year. So till the orders are enforced, till the orders are complied, this act is predominantly civil in nature, is a judgment of Bombay High Court in Nandakishore Vyavare case. As far as first aspect is concerned, the question may be there in your exam that the Domestic Violence Act of 2005 basically provides a remedy in the option may be civil law, criminal law, but as far as the statement, object, and reason is concerned, the answer is civil law, because there was no effective civil law till 2005, and it has been specifically mentioned in statement, object, and reason that with a view to provide effective remedy under civil law, and with a view to ameliorate the position of women in Indian society, this legislation has been enacted. And Nandakishore Vyavare judgment is there, which can support your contention in relation to the nature of this particular law. Now, another important aspect is there, that is Section 2 of the Act. Now, coming to first aspect, the question may be there in your preliminary exam that who may be an aggrieved person under Section 2A of the Act. Now, very importantly, Section 2A says that aggrieved person means any woman who is in domestic relationship with the respondent. And second aspect is there in Section 2A, that who alleged to have been subjected to domestic violence. So if question comes in your exam that who is aggrieved person under Section 2A of the Act, or the following person can be treated as an aggrieved person under Section 2A of the Act, the option may be a woman who is in domestic relationship. The answer is yes. And second is who alleged to have been subjected to domestic violence. So unless and until these two aspects are complied, that aggrieved person cannot be treated as an aggrieved person within the meaning of Section 2A, or any women cannot be treated as an aggrieved person. So sometimes it may happen, or in every case, the person is in domestic relationship with the respondent. But unless and until domestic violence is alleged by her, she cannot be treated as an aggrieved person. That's why women in domestic relationship is the first aspect. And second, that she has made allegation that she has been subjected to domestic violence are the two basic things which are required to satisfy the basic ingredient of Section 2A, that is who is aggrieved person. So aggrieved person means any woman who is in domestic relationship with the respondent and who allege that violence has been committed against her, or who has been subjected to domestic violence by the respondent. So women in domestic relationship, first aspect, an allegation that she is subjected to domestic violence are to be there if a person is to be treated as a aggrieved person. This is the first aspect. Now coming to second aspect, that domestic relationship. According to Section 2F, the question may be there that domestic relationship is there if following conditions are satisfied. Now, some conditions are laid down by Section 2F of the Act. And these conditions are there. First is that aggrieved person must have resided with respondent in a shared household. If aggrieved person has not resided with respondent in a shared household, then domestic relationship cannot be there. And after residing in a shared household, aggrieved person shall be related to respondent by consanguinity, by marriage, by relationship in the nature of marriage, by adoption, or even by becoming a family member living together in a joint family. So there are 4 to 5 important aspects mentioned by Section 2F of the Act, that domestic relationship is there when aggrieved person is related to respondent by number 1, consanguinity, number 2, marriage, number 3, relationship in the nature of marriage, number 4 is adoption, and number 5, by becoming a part of that joint family. So These 4-5 options shall be remembered so far as multiple choice questions are concerned. Now in 2016, one important development has taken place wherein some part of section 2Q has been struck down by Supreme Court of India or by Apex Court, and that is in relation to the definition of respondent. If you see section 2Q of the Act, it says that respondent means any adult male person who is having domestic relationship with the aggrieved person against whom she has filed complaint under the provisions of this Act. Now the word respondent means any adult male person. The word adult male was challenged in Supreme Court of India in Hiralal Harsora case of 2016. I will tell the citation. Hiralal Harsora versus Kusum, 2016, volume 10, SCC, page 165. In Hiralal Harsora case, Supreme Court of India clarified that the word adult male person which is there in section 2Q of the Act is violative to Article 14 of the Constitution of India. And by applying doctrine of severability, Supreme Court of India struck down the word adult male from the list of section 2Q of the Domestic Violence Act. And at present, the word adult male has been deleted from the list of section 2Q in view of Hiralal Harsora case. And now the result is that in the wake of this Hiralal Harsora case, even a female can also be a respondent. Not only male person, adult male word has been deleted now because the adult male person word was signifying that only male person can be a respondent. Female cannot be a respondent. But when the word is deleted in Hiralal Harsora case by Supreme Court of India by applying the rule of severability, now the position is that the word adult male has been deleted from the list of section 2Q of the Act. And at present, the settled position is that respondent includes not only male person, but respondent is even a female person also. Even the judgment of Kusumlata is there by Delhi High Court, wherein now Delhi High Court has clarified that not only a daughter-in-law can file complaint against mother-in-law, even mother-in-law also can file complaint against daughter-in-law. So the issue has been settled in 2016. Even prior to that also, there were some judgments wherein Supreme Court had clarified that respondent can be a female. But when the word male person was deleted from the list of section 2Q, now the position is that even female are also a respondent within the provision of this particular Act. And now coming to most important aspect, that is section 2S. In 2015 exam, there was a question on section 2S of the Act, that when share household can be treated as a share household. Now, for the purpose of complying the provision of section 2S about the share household, certain ingredients are to be satisfied. Then only that house can be treated as a share household. Now, a house can be treated as a share household if aggrieved person has resided with respondent in domestic relationship. So, if any house is to be treated as a share household, then that aggrieved person must have resided in that house with respondent, and she must be in a domestic relationship. Now, section 2S has applied 3 important criteria that which house can be treated as a share household, wherein the first aspect is there that a house owned by respondent can be treated as a share household. Secondly, even a tenanted house, a house taken on rent, can also be treated as a share household. And thirdly, a joint family house can also be treated as a share household irrespective of the rights of the parties. So it may happen that the house may belong to in-laws, and even the respondent husband is not owner of that. House is purchased by his father. Irrespective of the rights of the parties, that is husband or even applicant, aggrieved person, that house can be treated as a share household as it is a joint family house is contemplated by Section 2S of the Act. So the question was there in 2015 exam of family court judge that when share household can be treated as a household within the meaning of Section 2S. The answer are three options are there. If the house is owned by the parties, second is if it is a tenanted house, and thirdly, if it is a joint family house, irrespective of the rights of the parties in that particular premises. And first important criteria shall be remembered that domestic relationship shall be there if any house is to be treated as a share household. Now coming to another important aspect in relation to Section 3. As we know that definition of domestic violence has been given in Section 3 of the Act. Now, the starting words of Section 3 are saying, the question may be there in the exam, that domestic violence within the meaning of Section 3 includes, and the starting words are saying, any act of the respondent, any omission of the respondent, any commission by the respondent, or any conduct of the respondent. So domestic violence includes act, omission, commission, and conduct of the respondent. If there are these four options given, or three options are given, or in first option it may be there that act or omission, second may be their commission, third may be their conduct, and the fourth option may be there all of the above. In that case, the answer will be all of the above, because these four categories are included in Section 3 of the Act. Now, several categories are there, wherein some examples are given in relation to the instances of domestic violence, that what it includes. As we know that domestic violence includes physical violence, mental violence, verbal violence, emotional violence, even economical violence, even sexual violence, even demand of a dowry. If you want to read the examples in relation to the concept of or definition of domestic violence, you can read form number 4 of the Act. That's why sometimes question may be asked in your exam that the explanation of domestic violence has been given in which form, or in form number. There may be form number 2, 3, 4, 5. The appropriate answer is form number 4. And in form number 4, several examples are given that what is physical violence, what is mental violence, what is economical violence, what is sexual violence. So form number 4 is supportive to Section 3 of the Act, shall be remembered. Now coming to another important aspect, that is Section 4. Now Section 4 says that protection officer can take cognizance of any information even though the violence is not actually committed, but it is likely to be committed in future. If you see the first clause of Section 4, then information to protection officer can be given by any person who is a neutral person, any neighbor also, or any stranger also, or any family member, or any related person to that aggrieved person. And Section 4 says that if the domestic violence is committed, or if it is likely to be committed, it means that in actual practice it is not committed, but it may be committed in future, then such information can be given to protection officer. Now, very importantly, the question may be asked that when information is given to protection officer under Section 4 of the Act, then he has to file report before the court of magistrate as per form number 1, 2, 3, 4. The appropriate answer is form number 1. And form number 1 is nothing but domestic incident report. So if any information is acquired or received by protection officer under Section 4 of the Act, then he has to prepare a domestic incident report as per form number 1 of the rules. And if he has prepared that domestic incident report, he has to forward that report to the nearest magistrate within whose jurisdiction he is working. And any person who is giving information to protection officer in good faith is excluded or exempted from any kind of liability. And if you see clause number 2 of Section 4, then the exemption given to that particular person who is the informant is from civil as well as criminal cases. So if the question is asked that the information of domestic violence, if given by any person under Section 4 of the Act, is exempted from following liabilities, then the answer is civil as well as criminal. From both liabilities, he has been exempted. Now, before proceeding further, let me clarify another important aspect in relation to domestic violence. Question may be asked in an exam that the Supreme Court of India or Apex Court has evolved doctrine of continuing violence. And doctrine of continuing violence is related to following abuse, whether sexual, whether economic, whether mental, or whether physical abuse. So the appropriate answer is economic abuse. Doctrine of continuing violence has been propounded by Supreme Court of India in Saraswati versus Babu case. Saraswati versus Babu was decided by Supreme Court of India in 2014. I will tell the citation, 2014, volume 3, SCC, page 712. In Saraswati versus Babu, Supreme Court of India has clarified that whenever economic abuse is there, the violence is continuous in nature, and for that purpose, even retrospective operation can be given to the provision of this act. And in that case, limitation will not be applicable for filing of application under Section 12 of the Act. So Saraswati versus Bapu is an example of doctrine of continuing violence, wherein every day fresh cause of action is there to the accused person, and she can file application under Section 12 of the Act. But always remember one thing, doctrine of continuous violence is related to economic abuse. In case of economic abuse, Supreme Court has clarified about the violence. Now coming to Section 5 of the Act. There was a question in exam of 2018 about question number 5, that what are the duties and liabilities of magistrate or judge or police under Section 5. Basically, there are 3 important duties of these officers. He may be a judge, magistrate, or even a protection officer. They have to inform that particular aggrieved person that she is entitled to take assistance of protection officers. Secondly, she is also entitled to take assistance of service providers who are established under Section 10 of the Act. And third is, she is also entitled to take legal aid as per the Legal Services Authorities Act 1987. So if the question is asked about the duties of these particular officers, that he may be a protection officer or even a magistrate or judge, you can give the answer in relation to these 3 instances, that their duty is to inform the aggrieved person that she has a right to take assistance of protection officer. Secondly, she has a right to take even help of service provider. And thirdly, even she is entitled to take legal aid so as to defend her case in the court of law under the Legal Services Authorities Act 1987. Fourth important right is also there to that aggrieved person. That is, she shall be informed by these authorities that she has a right to make application under Section 12 of the Act for getting various reliefs which are guaranteed under Section 18 to 22. And very importantly, another important aspect may be there in relation to multiple choice question, that whether on the basis of the fact and circumstances of the case, whether the aggrieved person is entitled to file a complaint under Section 498A of the Indian Penal Code. That particular right has been provided to her by Section 5 of the Act. So, very importantly, civil remedy under Section 12 of the Domestic Violence Act and criminal remedy under Section 498A of the Indian Penal Code will go together, will go parallelly at the same time. And that right of that aggrieved person to move or make a complaint against respondent under Section 498A is provided in Section 5 of the Act. So it is the duty of the police, if any aggrieved person approached to police by saying that she has been ill-treated by her husband or by respondents, then it is the duty of the police to inform her that she is entitled to file complaint under section 498A if they came to know from that particular information that respondent has committed cognizable offense. And even other authorities like protection officer and even magistrate are also bound to inform that particular aggrieved person that she has a right to make complaint under section 498A if it discloses prima facie the commission of any particular cognizable offense under section 498A. So 5 important aspects are there that may be a part of multiple choice question, that the duty of these officers is to make aware that aggrieved person that she has a right to file application under section 12, number 1. She has a right to take assistance of protection officer, number 2. She has a right to take help of service provider, number 3. She has a right to take or obtain even legal aid under the Legal Services Authority Act 1987. And fifthly, she has even a right to make a complaint under section 498A of the Indian Penal Code if prima facie the allegation discloses the commission of cognizable offense. Now coming to section 6, shelter home. As far as section 6 is concerned, it is having nexus with section 17 and section 19 of the Act. Section 17 and 19 speaks about right of residence in relation to that aggrieved person. So if any particular aggrieved person is evicted from share household, and if there is no provision for her residence, then it is the duty of the state government to make a provision for that particular lady under section 6 of the Act, which speaks about shelter home. After that, section 7 is there, which deals with medical facility. As a part of violence, sometimes it may happen that aggrieved person may be injured. In that case also, certain duties are cast on the state medical officers to examine that particular aggrieved person medically and to provide her a medical help. So section 6 deals with right of residence in a shelter home for that particular aggrieved person. And secondly, right of medical examination or right of medical facility is also provided to her under section 7 of the Act. Now section 8 and 9 deals with appointment of protection officers and functions of protection officers. Section 8 is very basic that state government has to appoint protection officers. State government can define the numbers of protection officers who can be appointed. That question was there in the exam, that how many protection officers are to be appointed. Now that is the discretion of the state. Any number which are required can be appointed by the state government is a specific answer to that question. And section 8 also further says that as far as protection officer is concerned, it may be a woman. So state government shall give priorities to appoint women as a protection officer. Now, so far as section 9 is concerned, it is very important as it deals with functions of protection officer. Now, protection officer has to discharge some functions under section 9, right from information of domestic violence till the execution of order of magistrate. Protection officer has to work under the supervision and control of judicial magistrate first class, and that is specifically provided by the Act. So if question comes that the protection officer under the Act of 2005 is supervised and controlled by, the options may be there like service provider, state government, judicial magistrate first class. The appropriate answer is judicial magistrate first class is a supervisory authority or controlling authority in relation to the protection officer. And if you go to section 10 of the Act, there is a provision for registration of some NGOs who are working for the cause of women, and they can be registered as a, we may say, service provider within the meaning of section 10. And if you see section 9 and section 10, section 9 speaks about the functions of protection officer and section 10 speaks about registration of service providers. There is one similarity between these two important authorities or machineries which are created under the Act. Two similar functions can be exercised by them, by protection officer as well as service provider. So the question may be there in your exam that the service provider and protection officer can file domestic incident report in magistrate court as per which form? I told earlier that is as per form number 1. But another important aspect is there, that is both have same function given in section 9 and 8. 9 and 10. That is duty to take medical examination of that aggrieved person. So they have to medically examine that aggrieved person if any injury is there as a part of domestic violence. So filing of DIR report, that is domestic incident report, and conducting medical examination of that aggrieved person are two important functions of that particular protection officer and service provider. Coming to section 11, certain duties of government has been given. As I told earlier, that protection officer is there, service providers are there, even police machinery is also specified in section 5 of the Act, and even magistrate is also defined in section 2 of the Act. His duties are given in section 5. Application can be filed before him under section 12 of the Act. So certain stakeholders are created under this particular Act in the name of protection officer, service provider, even judges, that is judicial magistrate first class, and against police officer in section 5 of the Act. So duties of government are given in section 11, that what government shall do. First aspect is there, that government has to work for effective coordination between these authorities. And for that purpose, government has to conduct several, we may say, training courses for them. Government has to sensitize them in relation to the provision of this Act. And government has to conduct even awareness program about the implementation of this particular program in respective states. So we may say that the duty to make coordination within the authorities which are created under the Act, the duty to give them proper training, duty to even sensitize them in relation to this particular Act, because the Act is a social legislation, a beneficial legislation. So to sensitize them in respect to the implementation of the Act is also one of the important duty of government under section, we may say, 11 of the Act. Now, coming to a very important aspect which is there, that is section 12 of the Act. Now, as far as section 12 is concerned, very importantly, I think in last exam, more than 4 to 5 questions were asked on this particular topic. First aspect is there in section 12, that who can file application before the magistrate. In 2015 exam, this question was asked. Now, section 12 provides that aggrieved person or protection officer or any other person on behalf of aggrieved person is entitled or can file application before the magistrate under section 12 of the Act. So application can be presented either by protection officer, by aggrieved person herself, or by any other person on behalf of aggrieved person. This question was asked in 2015 exam. The answer was option number 4, that is all the above. Because if aggrieved person files application, then there is no question of filing application by protection officer. If aggrieved person approach to protection officer seeking his help, then protection officer can file application on behalf of her under section 12. Or sometime it may happen that any relative of aggrieved person, that is her father, her brother, her mother, or any other close relative may come forward and they may also file application on behalf of aggrieved person. So the answer is clear, that either she can file application, if not, then protection officer or any other person. So there are 3 options and all are correct so far as section 12 first part is concerned. Now second part is there, that is, while disposing of an application under section 12, magistrate shall take into consideration the domestic incident report filed by protection officer under form number 1. That is also important aspect to know. Second aspect is there in clause number 2 of section 12. There is a provision of set-off. If any damages or compensation are claimed by aggrieved person under section 22 of the Act, see section 22 is having nexus with section 12 clause 2. What section 12 clause 2 says? If any compensation or damages are claimed, and if they are also given to aggrieved person under any other law or in any other case, then the amount of that particular damages or compensation can be set off under section 12 clause 2 of the Act. So the provision of set off is provided in section 12 clause 2 of the Act is second important aspect of section 12. Now third important aspect is there, that as per which form the complaint is to be filed by aggrieved person before the court. So the proper answer is form number 2. If you go to the rules, there is form number 2. And this particular form number 2 provides that as far as complaint filed by aggrieved person is concerned, it shall be as per or in accordance with the form number 2. Now, there are some judgments of even High Courts also that even though that particular complaint or that particular application is not as per form number 2, then also it is maintainable. But as far as possible, the format given in form number 2 is to be seen at the time of filing of the complaint or application. Now, another question was asked in 2015 and even 2010 for family court exam, that magistrate shall dispose of an application filed under section 12 within 30 days, 60 days, 90 days to 20 days. So the proper answer is 60 days. Within 2 months, the application is to be disposed by magistrate, or he shall try. The magistrate shall try to dispose that application within 60 days. In 2015 exam and in 2010 exam, this question was asked that magistrate shall dispose an application filed under section 12 within. Options were given. The proper answer is 60 days. As you know that we can file application under section 12 of the Act before magistrate. Now, after filing of the application, magistrate has to fix the first date of hearing, and the proper answer is within 3 days from the date of receipt of application. So when application is received by the court, within 3 days, the first date of hearing is to be fixed. This question was also asked in last exam of family court judge. So section 12 is very important, even though we are dealing with the exam of family court judge, and despite the fact that section 12 deals with application before the magistrate, but there are 4 to 5 times I think the questions are asked in family court judge exam in relation to section 12, that when the application is to be disposed, what is the time duration provided by the Act, who can file application before the magistrate, within how much time after filing of the matter or after receipt of the matter, the first date of hearing is to be fixed. These kind of questions were asked in family court exam. Now, another important aspect is there, that is section 13 of the Act. Now, when application is filed under section 12, magistrate can issue notice to respondent, or service of notice is to be there to respondent under section 13. Now, as far as section 13 is concerned, the person who has to effect that service to respondent is the protection officer. So it is not a police or court machinery, but the Act has provided one important alternative to this particular general practices. That is, the protection officer has to serve the notice to the respondent. And again, section 14 is there in relation to counseling. Now the question is, when counseling is to be conducted? When parties have appeared before the court, that is applicant and respondent, court can send that matter for counseling. And that counseling can be conducted by service provider under section 14 of the Act. Now, who is a service provider is discussed by us while discussing section 10 of the Act. Service provider is a NGO or an organization which is working for the cause of women. And these experienced organizations are registered by Women and Child Development Department as a service provider under Section 10 of the Act. And as far as Section 14 is concerned, the duty of counseling of protection, the applicant and respondent has been given to service provider. Now, if a matter is referred to counseling, then it cannot be disposed within 60 days as per the mandate provided by Section 12. So matter is to be adjourned for some time. For how much time the matter is to be adjourned is provided by Section 14 of the Act, Clause 2. So if matter is adjourned to counseling, then next date of hearing can be fixed, not exceeding 2 months is an answer provided by Section 14 Clause 2. It means that adjournment can be given for counseling, but not exceeding more than 2 months. And after that, if no settlement is there, or if counseling is not successful, then court can proceed with the matter. When court has proceeded with the matter, then Section 15 comes into play. There are some welfare experts who are working for the cause of women, or they are working for the rights of women. Court can take assistance of these welfare experts under Section 15 of the Act. So, the machinery of welfare expert is recognized by Domestic Violence Act under Section 15 of the Act. And when trial begins, and when there is a opening of the case by even applicant by filing her chief affidavit, it may happen that certain circumstances may warrant, the fact and circumstances of the case may be such that they may warrant, or even in some cases the party may desires that the proceeding shall be conducted in camera. So there are two important requirements given in Section 16, that in camera proceeding under the Domestic Violence Act 2005 may be conducted when, first is if the circumstances of the case warrants, and second is if the parties of the proceeding desires. Both the answers are correct so far as your exam is concerned or pre-exam is concerned. So if the fact and circumstances of the case warrant, or if the party desires, then court can pass a order, magistrate can pass a order, and he can conduct that particular proceeding in camera. Now coming to Section 17 of the Act. Section 17 speaks about right to share household. Now, right to share household is given to every person by Section 17 Clause 1 of the Act. And this right is given to her irrespective of the fact that whether she has title of that particular house or not. So she may not have a title of that house or any interest in that particular house or any right in that particular house till she has a right to reside in share household. And now Apex Court has clarified that right of residence is a higher right as far as Section 17 Clause 1 is concerned. So right to reside irrespective of the title or right which she is having in that particular property is recognized by Section 17. And Section 17 Clause 2 says that the aggrieved person cannot be evicted, or she cannot be excluded from that share household without the procedure established by law. So without resorting to the procedure which is given by law, that aggrieved person cannot be evicted by respondent from that particular share household. So Section 17 recognizes right of aggrieved person in relation to right of residence. And first aspect is that right to residence is a higher right. So right to reside is guaranteed by Clause 1. Even though she is not having right in that house, that right is protected and recognized and enforced by this particular act. And secondly, it has been specified that under certain circumstances, she may be denied right to reside in that house. But for that purpose also, one exception is provided by Section 17 Clause 2, that is a procedure established by law. She cannot be evicted from that house unless the procedure is established by law. So by resorting to proper procedure only, she can be evicted from that particular house. Now after this, another important aspect is there, that is section 18 of the Act. Now under section 18, court can pass protection order. And by that protection order, certain directions can be given by court to the respondents. So if question comes that protection order may be passed by which respondent can be, number one, prevented from aiding the domestic violence. Number two, entering the place of employment of the applicant. Number three, not to communicate with the applicant. Number four, not to alienate the assets of the applicant or even of the respondent. So in that particular case, if these four options are there, or if these four options are clubbed in three options, and if fourth is given all of the above, then fourth will be your proper answer. That is, protection order may be in these four forms or any other order which the court required to pass as per the fact and circumstances of the case. Now, very importantly, if a question comes in your exam that causing of violence to dependent is prohibited by which section of the Act? That is section 18. So this is the only clause in Domestic Violence Act wherein protection order can be passed even in favor of a male person also. So if father of that aggrieved person is protecting that aggrieved person, and if she is dependent on him, then even magistrate can pass a order, and magistrate can direct the respondent not to cause violence even to the dependent of the aggrieved person. So this is very unique remedy provided by section 18 of the Act, wherein not only the aggrieved person but even her relatives can also be protected by the court by passing a protection order. Now after this, very importantly, another important aspect is there, that is section 19. In 2018 exam, one question was asked that which of the order magistrate can pass under Domestic Violence Act. The options were there, that is protection order and residence order, then monetary relief, custody order, and compensation order. And the answer was all of the above. As you know that under section 18, protection order can be passed, under section 19, residence can be passed, under section 20, monetary relief can be passed, under section 21, custody order can be passed, and under section 22, compensation order can be passed. So all these 5 orders can be passed by magistrate under section 18 to 22 respectively. So the answer is all the orders which are mentioned above. Now coming to section 19 of the Act. Under section 19 of the Act, magistrate can pass residence order. And residence order may be in several forms. Number one, if the applicant is residing in a shared household, then respondent may be directed or he may be restrained from dispossessing her from that house. So first important remedy or first important residence order is restraining from dispossession of applicant. Number two, if the respondent is residing in a house and if he is causing violence to applicant, then court may direct him to remove himself from that house. So removal of respondent is also residence order. Third is the entry of respondent may be even restricted by the court. So he may be restrained from entering in that particular house. All these three are nothing but we may say residence order under the provision of the Act or section 19 of the Act. Besides this, not to renounce the rights in the house or property, or even not to alienate the property, are also two important instances of residence order. So residence order may include, if the question is there, then these 5 options are to be remembered. Besides these 5 options, another option is there, that is alternative accommodation. So the respondent is also liable to provide alternative accommodation to applicant under section 19 of the Act. one unique remedy has been provided by Section 19, that is return of Sridhan. Even though Section 19 speaks about right of residence, even aggrieved person is entitled to claim Sridhan from respondent as per Section 19 of the Act. So, besides right of residence, even return of Sridhan is also mentioned in Section 19 of the Act. Now, coming to Section 20, that is monetary relief. Now, in Section 20 of the Act, the word maintenance is not given. The word which is mentioned in title of Section 20 is monetary relief. If question comes in your exam that monetary relief can be granted under Section 20 of the Act for number 1, loss of earning, number 2, medical expenses, and number 3, loss to the property. All these 3 options are correct because clause 1 of Section 20 provides that aggrieved person is entitled to claim monetary relief for loss of earning, for medical expenses, and even for loss to her property. And Section 20 also provides that monetary relief granted under Section 20 may be in addition to the maintenance which is granted to aggrieved person under Section 125 of the CRPC. So very importantly, please remember one thing, that Section 20 has recognized the concept of multiple maintenance. Even though maintenance is granted under any other law, it can also be granted under Section 20 of this Act. Because Section 20 specifically says that the monetary relief granted under this section shall be in addition to the maintenance which is granted under Section 125 of the CRPC. Now, question may be asked in your exam, which is one of the important facets of Section 20. That is, the standard of living to which dash dash person is accustomed shall be considered while granting monetary relief. Now, standard of living of whom? Of aggrieved person or of respondent? The answer is aggrieved person. So, court has to take into consideration the standard of living to which the aggrieved person is accustomed. So aggrieved person is the proper answer in relation to that particular point. Again, Section 21 is there, which deals with custody order. If the custody of child is with respondent, then court may even grant that order in favor of that aggrieved person, and custody can be given to her. Besides this, Section 22 is there, which deals with compensation. As a part of domestic violence, if any physical or mental cruelty is there, then as a part of that physical and mental cruelty, the aggrieved person is entitled to claim compensation from respondent. And that compensation is different from maintenance or from monetary relief, which is granted under Section 20 of the Act. So at the final stage of the matter, when Exhibit 1 or Section 12 application is decided by court under Section 12, respondent can be directed by the court to pay compensation to the aggrieved person under Section 22 of the Act. Now, Section 23 deals with interim order. Section 23 Clause 1 deals with interim order, and Section 23 Clause 2 deals with ex parte ad interim order. Now, interim order can be granted till further orders or till the disposal of main application filed under Section 12. But on the first date of hearing, if applicant prima facie satisfies the court that interim or ad interim or ex parte ad interim relief is required, then at the time of issuance of notice, magistrate can pass ex parte ad interim relief. And after granting ex parte ad interim relief, court can issue notice to the respondent. If ex parte ad interim relief is not granted, and if notice is issued to respondent, and if respondent has appeared before the court and if there is some time for disposal of interim application, then applicant can claim add interim order till the hearing of interim application. So please remember, ex parte ad interim order is one thing and ad interim order is another thing. Ex parte ad interim order can be granted in absence of respondent because matter is filed today and before issuance of notice, ex parte order is passed by the court. And always remember one thing, ex parte ad interim order can be passed by a court only when the applicant has filed affidavit as per form number 3 of the rules. So affidavit in terms of form number 3 is always required. It is a mandate provided, and there are also judgments of the court wherein it is provided that affidavit under form number 3 is required for claiming ex parte ad interim relief. In absence of respondent, that order can be granted. But when respondent appeared before the court, then till the hearing of interim application, ad interim relief can be granted, which is temporary in nature. And then court can hear Exhibit 5 or interim application. Then interim application can be granted under Section 23 Clause 1. So Section 23 deals with interim orders or ex parte ad interim orders or ad interim orders till the hearing of interim application. Now coming to Section 24 of the Act. If any order is passed under this Act, then court has to give copy of that order free of cost to both the parties. Now coming to Section 25. Section 25 deals with modification, alteration, and revocation of order. And Section 25 says that any order passed by the court can be altered, can be modified, and can be revoked by the court. But very importantly, always remember one thing. As far as Section 25 is concerned, the order of magistrate can be modified, can be revoked, can be altered only in changed circumstances. So there may be a question in your exam that court can modify, alter, or revoke the order passed under Section 25 when there is a change in circumstance. Change in circumstance is the proper answer. If there is no change in circumstances, then Section 25 cannot be applied. Now I will give a simple example. When maintenance order was passed, husband was earning 10,000 rupees per month. But after that, he got a job and now his salary is 1 lakh. In that change circumstances, wife can again go under Section 25 for alteration of the order and she can ask more amount from the magistrate. And that application can be considered by the court under Section 25 Clause 1. And as far as another clause is concerned, Section 25 specifically says that the protection order which is granted under Section 18 of the Act cannot be revoked, cannot be cancelled till the applicant applies for discharge. So it is the requirement of the applicant. If she wants enforcement of that order, continuance of that order, then that order will prevail, that order will be continued. And if she wants to cancel that order, then she has to apply for discharge under Section 25 of the Act. After considering her application only, court can discharge the protection order. Now coming to Section 26. It's very important section is there, that is Section 26, which speaks about relief in other proceedings. Now, if any matter of applicant and respondent is pending in any civil court, any criminal court, or even a family court, then any remedy which can be claimed under Section 18 to 22 of the Act can also be claimed in that pending proceeding. So, in a marriage petition also, wife can claim right of residence. Wife can claim even protection order under Section 18 of the Act. And if you see Clause 1 of Section 26, it says that in a pending proceeding before civil court, criminal court, and even family court, even in 498A proceeding also, 498A proceeding also, wife can file application under Section 26 of the Act and she can claim protection order because that right is provided to her under Section 26 Clause 1 of the Act. And section 26 clause 2 further says that the relief which is granted under clause 1 can be granted along with or in addition to the remedy which she has claimed in that particular pending proceeding. So a very wider scope is there to section 26 of the Act. If I am asked that which section is more important in the Domestic Violence Act, I will refer to section 26 because section 26 has given very wider connotation to the forums wherein applicant can approach and she can claim various remedies which are available in a proceeding under Domestic Violence Act. And while claiming that remedies of protection in pending proceeding, there is no need to file even domestic incident report by a protection officer. Or without approaching to magistrate under section 12, in a pending proceeding, she can file one simple application under section 26 and she can claim the reliefs which are available to her under Domestic Violence Act. But there is one, we may say, rider given in section 26 clause 3. One condition has been specifically mentioned that if a maintenance is provided to applicant in any other proceeding, now presume for some time that wife has filed application under section 12 of the Act in magistrate court and 10,000 rupees maintenance has been granted. Or wife has filed application under section 125 CRPC before magistrate and maintenance has been granted to her. And again, in a pending proceeding before family court, that is a marriage petition, again she has filed an application under section 26 and she is claiming maintenance. So multiple maintenance can be claimed by her. It is a right guaranteed to her. But section 26 clause 3 is saying that in such kind of contingency, in such kind of, we may say, circumstances or facts, it is her duty to inform the court that in that proceeding or in another proceeding, such kind of amount has been granted to her. So she has to inform the court, the family court or any other civil or criminal court that I have been granted 10,000 rupees by JMFC in section 12 proceeding. Why this information is required? Because the court wherein the matter is pending, suppose a marriage proceeding, the court can consider the earlier amount which is granted to her and that particular amount may be set off. So provision of setup can be there, that amount can be adjusted. So if no application is filed in any other court, maintenance of 20,000 rupees may be given by family court. But if another court has given 10,000, then here court may give 10,000 by adjusting that earlier amount. That is one of the basic object of section 26. So section 26 has given remedy to the wife or to the aggrieved person that she can claim all the remedies of domestic violence right from section 18 to section 22 in any pending proceeding, in a 498A proceeding, even in marriage proceeding, or even in custody matters also under Guardian and Ward Act. But very importantly, what is provided by section 26 is that if any relief of maintenance is granted to her in any other proceeding, then she has to inform that when application is filed under section 26 so that the amount can be adjusted. Now coming to section 27, the forum of entertaining application. This question was asked in 2018 exam that what is the jurisdiction of the magistrate where the applicant can file application. There are, I think, more than 8 options available to her. The first is the place where she is residing permanently. Second is the place where she is residing temporarily. Now, temporarily shall not be confused with casual visit. So, if she went to her relative's place for 2 days, then that cannot be treated as a temporary residence for filing of application under section 12. So, certain criteria are given by section 27 that which forum can entertain or where the application can be entertained. Answer number 1 is there. That is where the applicant is having permanent residence. Second is where she is having temporary residence. Number 3, where the cause of action has taken place. Number 4, wherein she is carrying on business. Number 5, where she is employed. These 5 options are available to her. If she don't want to avail these 5 options, that she is residing permanently, suppose in Pune, or she is residing temporarily in Pune, or she is the cause of action has happened in Pune, or she is doing business in Pune, or she is employed in Pune, and she don't want to file application in Pune. In that case, Section 27 has given another 3 options. That is, number 1, where the respondent resides. Number 2, where the respondent carry on business. And number 3, where the respondent is employed. This question was asked in 2018, that the forum of entertaining application is, the answers are there, that is permanent residence, temporary residence, or cause of action. All the above answers are correct. Now coming to section 28 of the Act. Section 28, clause 1 says that while disposing of an application under section 12, 18, 19, 20, 21, 22, and 23 of the Act, magistrate shall follow the procedure as laid down under the Code of Criminal Procedure. So CRPC procedure is applicable according to section 28, clause 1. And clause 2 says that while disposing of an application under section 12 and 23 of the Act, magistrate may adopt his own procedure. So if question comes that under which section the magistrate is having inherent jurisdiction to follow his own procedure, then the answer is section 28, clause 2, wherein magistrate can adopt his own procedure. Now, magistrate can adopt his own procedure doesn't mean that he can do anything. Certainly, he has to follow the principles of natural justice, and there are several judgments of even several high courts that if the procedure adopted by magistrate is arbitrary in nature, then it can be set aside or it can be challenged. Now, coming to section 29. Now, section 29 says that where appeal is to be filed. Now, always remember one thing, every order passed by magistrate under this Act is appealable. An appeal can be filed to Sessions Court within 30 days from the date of order. Now, very importantly, not only applicant but even respondent is also entitled to file appeal before the Court of Session under section 29 of the Act. And coming to section 30 of the Act now, who are public servants under section 30 of the Act? Protection officer and service providers are recognized by section 30 of the Act as a public servants. Now, very importantly, they are not declared as public servant as per section 21 of the Indian Penal Code. They are declared as a public servant under section 30 of the Act. That shall be remembered. Now, according to section 31, if any protection order or interim protection order is passed by the magistrate, then there were questions asked in the exam that if there is breach of protection order, then the punishment provided by section 31 is, number 1, 20,000 rupees fine to the respondent, and number 2, 1 year imprisonment. So that is a punishment provided for violation of protection order, breach of protection order, or even breach of interim protection order. So section 31 doesn't punish only violation or breach of final protection order. It also provides punishment for breach of even interim protection order. And if you go to section 32, again question was there that breach of protection order is, answer is cognizable and non-bailable. Section 32 says that if there is a breach of protection order committed by respondent, then it is cognizable as well as non-bailable, and on the sole testimony of a good person, court will come to the conclusion that there is a breach of protection order and respondent can be punished. Now, there was a question in your exam in relation to section 33. In last exam, there was a question that if there is a breach of duty by protection officer, if he has not acted in good faith, then even punishment of 1 year and 20,000 rupees fine can be imposed on protection officer. So penal liability is imposed on protection officer under section 33 of the Act, and the liability is 1 year punishment and 20,000 rupees fine. But the rule is that if they have not acted in good faith, if negligence is committed by them, then certainly that punishment can be imposed. But section 34 further says that if protection officer has acted in good faith, then no liability can be imposed on them. And section Even further section 35 says that sanction is necessary. And section 36 says that the provisions of this act are in addition to and not in derogation to any other law for the time being in force. And according to section 37 of the act, central government is having power to make some rules. And as I said earlier at the very outset, that in 2006, 17 rules are made by central government. And by making these 17 rules from 26th October 2006, the provisions of this act are implemented in entire India. I'm very much thankful to Bar Council of Maharashtra and Goa for giving me an opportunity to discuss the provisions of Domestic Violence Act in point of view of preliminary examination. Thank you very much.
May please take the vote of thanks.
On behalf of Bar Council of Maharashtra and Goa, I would like to extend my heartfelt thanks towards our today's chief guest, Advocate Dr. Rajendra Anbhule sir, for giving a very informative session on the topic of protection of women from Domestic Violence Act 2005. Sir, this was a very informative session from the exam point of view. I would like to extend my gratitude to a chairman, vice chairman, and all the esteemed members of Bar Council of Maharashtra and Goa. I would like to extend my special thanks towards Vice Chairman of Bar Council of Maharashtra and Goa, Dr. Uday Varunzikar sir, who is also a coordinator of this lecture series. Thank you very much, sir, for organizing a very informative lecture series. Now I would like to extend my thanks towards all the participants for participating in this lecture series. I am requesting Sharat sir to conclude this meeting. Thank you each and everyone.